The Honorable the Vice President.
Senator Seepersad.
Thank you, Mr. Vice President. In reviewing the proposed amendments to the Magistrates Protection Act, I'm of the view that what is being proposed should be no less than what judges in the High Court and the Court of Appeal enjoy. The Attorney General already gave all the information on the number of matters that go before the magistrates' courts and so on. I'm not going to bore you with that, even though I did all the research. So we should offer protection to our magistrates, whom Senator Vera eloquently described as the engine room of the legal profession, well, the judiciary. So we really must give the magistrates protection, and I am going to support that. But there's something else that I want to raise. I'm just looking at this thing from a business point of view, that when claims are made, what the government really should do is set up a self-managed fund to cover the costs of claims made against the judiciary. The fund, I'm just going to briefly go into it. This is not the how to do it, but it's just I'm making a suggestion that could be taken up. The fund will require an initial cash injection and needs to be managed effectively, and it will be able, eventually it will grow to be able to cover the costs of claims awarded against the judiciary. Of course, the fund will have to be managed in a similar manner to a pension fund. And that way, instead of relying on the state resources, you have a fund that is self-managed and self-generating. I did look at professional indemnity insurance, but that is prohibitively expensive. So I would really like to recommend that somebody in the government take this on and look at it from a business point of view to mitigate against losses and costs. Thank you very much.
Senator Ahye.
Thank you. Thompson-Ahye is my name. I'm in support of this bill to amend the Magistrates Protection Act. Some years ago, a woman came to me in my office, and she brought with her a notice of appeal. I looked at the notice of appeal. Subsequently, I was able to look at documents that came with it. Now, when a notice of appeal is filed from the magistrate's court, the magistrate is supposed to write reasons for the decision. Instead of a reason for the decision, what was included with the documents is a statement which I call a mea culpa. What the magistrate said is that I accept responsibility. I did not follow the correct procedure. Instead of taking evidence from the witness box, I questioned the defendant from behind the bar. Now, this was a case of maintenance of a child. And I must say, it was pre the Single Fathers Association. Otherwise, you would have heard the gentleman on the issue. So there was the father, and he was appealing to the Court of Appeal because he said, well, I suppose the maintenance was too high. But once the magistrate had put on record that she had followed the wrong procedure, she now holds high office. She was very candid. She didn't hide or make up any story. She said, this is what happened. So I explained to my client what's going to happen is that the Court of Appeal is going to try the matter de novo. And I explained to her the matter will have to go back downstairs. And worse yet, there was a Guyanese case I had found that was right on all fours, as we lawyers say, right on point. So there is no way we could have succeeded. So I went into the Court of Appeal to say I cannot resist the appeal. But something strange happened in the Court of Appeal. Things went a little funny for a bit. And finally, after, I don't want to go into details because of ethical issues, but finally the matter was sent back downstairs. So the magistrate fell into error. And that showed me that people can make mistakes. People can be honest about making mistakes. There was absolutely no malice. And I thought if the Court of Appeal had fallen into error, the judges would have been fully protected. If this man had decided to take another course, the magistrate might have been in trouble. Because many times magistrates are subjected to a lot of negative things. And all they're trying to do is to do the best they can. Now, I heard about the independence of the judiciary, and one might ask, what is the link between liability and independence? And I want to quote, if I may, sir, the Civil Liability of Magistrates International Standards, New Legislative Tendencies, by Christy Daniel, a judge. And the rubric, the compatibility between the civil liability and the independence of the magistrates. And she says, it is questioned to what extent the existence of some regulations in the matter of the liability of magistrates for judicial errors affect the principle of the independence of judges. This is because the independence is a legal act of carrying out justice impartially, but the possibility of a civil liability of the judge in a certain moment can be pressure factor on him that might negatively influence his solutions resulting from his desire not to become responsible for any errors. So we don't want any pressure to be brought to bear on any judicial officer. So I fully support the amendment that is being put forward today. And again, in terms of the independence of the judiciary, I want to quote from a statement, the Statement of Principles of Independence of the Judiciary, drawn up by the Conference of Chief Justices in Central and Eastern Europe, published in October 2015. And it states in part, the maintenance of the independence of the judiciary is essential in the attainment of its objectives and the proper performance of its functions in a free society observing the rule of the law. And it continues, judges shall exhibit and promote high standards of legal knowledge and judicial conduct in order to reinforce public confidence in the judiciary, which is fundamental to the maintenance of judicial independence. So I tie up the question of independence with legal knowledge. And we must not forget that this case, which has been the impetus for the amendment that is now before us, arose out of a case which dealt with juvenile justice, or the preferred term now, child justice. It is important for the independence that the same alacrity with which we brought this amendment must also be used in making sure that judges and magistrates are fully au courant with the law, that they are trained in all of the principles. And when we're talking about juvenile justice, there are certain principles, certain international umbrella principles with which they should be familiar. And the one that would have been operating in this case is the fact that one must always bear in mind that detention is a matter of last resort and for the shortest appropriate period of time, so that when the magistrates or whoever is adjudicating a juvenile justice matter or child justice matter, they must be fully au courant with all of these principles so that they would know how they should act in each particular case. So I make a case here for the education and continued training, and that question of continued training of the judiciary in juvenile justice principles is one that was recommended to us when the Committee on the Rights of the Child sat and looked at the report that we submitted to them in their concluding observations. They made sure to mention that our personnel must be trained in these principles. So I am asking that in addition to what we're doing here today, that the Attorney General be cognizant of the fact that the lower judiciary must be fully supported in their quest for training and their quest for continuing education. We do not have a system of continuing education like they do in Jamaica. You do not get a practicing certificate in Jamaica unless you have shown that in the preceding year you have followed a system of continuing legal education. So all of these things bring them together when we're talking about the independence of the judiciary. So I support the amendment, but I would also like to see further training and continuous education of all the members of the judiciary, especially those who are dealing with these matters which impact the rights of the child to the justice which this child is supposed to have and the rights that they must have, that we promise to give to them. Thank you.
Minister of Agriculture, Land and Fisheries.
Thank you. Thank you, Mr. Vice President, for the opportunity to speak on this bill for an act to amend the Magistrates Protection Act, Chapter 603. Mr. Vice President, I've been keeping score. So the first thing I'll say is that there is no dispute amongst the speakers on the need for immunity. I think we've agreed that. There is no dispute amongst the speakers on the need for parity. We recognize that magistrates do not currently enjoy a protection that is afforded to other judicial officers. The third point I'd make is that the discussion really resides on the issue of how far do we go today. On one hand, we have the opposition, who believes that there should be full immunity, but that the consolidated fund should bear the costs directly. And in pursuance of that view, they've put forward, my colleagues have put forward, the new Clause 4. The government's view is different. Not that we believe, Mr. Vice President, that we offer perfection, but we believe that what we offer today is sufficient to deal with the mischief that is before us. And maybe on another occasion, Mr. Vice President, we'd come back to this House to do something more with this piece of legislation. But what we believe today, Mr. Vice President, is that there should be absolute immunity in relation to matters within a magistrate's jurisdiction. So that's the first order of business. We believe that there should be absolute immunity. And for that purpose, we've offered a new Section 4, repealing the existing Section 4 and replacing it with a new provision which provides absolute immunity when a magistrate is acting within his or her jurisdiction. The second area of debate is this area of absolute or non-absolute immunity when a magistrate is acting without jurisdiction or in excess of jurisdiction. Which brings me to, Mr. Vice President, a purely academic point that I want to make just so that we understand that this debate is not new. I didn't have to go far, I didn't have to work hard to pull an article from 1943. It's titled Personal Liability of Administrative Officials. The writer is Eugene J. Keefe, and it's from the Fordham Law Review, Volume 12, Issue Number 2, 1943. And the article deals with this very issue, this issue of absolute and non-absolute immunity. And I want to read, put on the record just a short paragraph, and I quote, "The courts have established certain principles which seem simple when applied to ordinary factual setups, which come to mind immediately upon the statement of the principles themselves. But when life itself casts up situations less tailor-made for enclosure within these principles, difficult problems are presented, and the application of the principles seem to have been dictated by unstated realistic consideration," end of quote. What they're saying simply is that the work of a judicial officer sometimes relates to matters for which there are predetermined outcomes. But there are occasions when a judicial officer will be dealing with something that is novel, complex, or where the law or the legal principles have not made provision. And my colleague, the Attorney General, recited some of the more recent legislation that will throw up some new, complex, or ground that we've not traversed before. And the purpose of the absolute immunity is to ensure that our judicial officers enjoy some level of protection. And there was a time, Mr. Vice President, when absolute immunity was actually the law, the norm. In fact, it was referred to in 1800s in North America and even in Europe as the sacred principle, being so deep-rooted in the common law. But of course, the reality of jurisprudence step in, and the need to balance between the judicial interest and the public interest stepped in. And out of that came a series of provisions which took away absolute immunity in some cases, particularly where a judicial officer was shown to be malicious, capricious, or acting fraud, or acting in a very corrupt manner. So that what we have before us is an amendment to the existing Section 5.1, which allows someone who wishes to bring a claim against a magistrate for acting outside of his or her jurisdiction or in excess of that jurisdiction to bring a claim. But that claim requires that the thing that is complained about must be something that was done maliciously and without reasonable and probable cause. So it is not simple. And I believe that that is where my friends in the opposition are going. Perhaps, and I understand their view, that even in giving an opportunity to somebody who has something to complain about, we've given them an opportunity that contains a few hurdles. The first of which is to establish that the magistrate has acted without jurisdiction or in excess of jurisdiction. The second of which is to establish that what has been done was malicious. And the third area is to establish that it was done without reasonable and probable cause. And Madam, Mr. Vice President, it is not something, it is not an area, and it is not a provision that is without companion across jurisdictions, even in this region. In Bermuda, for example, it is not something, it is not a clause that is new or novel for us. It is a clause that finds company across jurisdictions. And I understand that the opposition wants us to go the furthest point. But I believe that this bill brings us to a point that magistrates can feel comfortable and the public can feel comfortable. I think it strikes the right balance. It provides absolute immunity with the introduction of a new Clause 4, and it gives someone who has something to complain about an opportunity to do so, again, providing a level of protection to the magistrate by putting 3 hurdles over which they must go. But if they get over the hurdles, then they will be compensated or they will have their remedy. In addition to which, Madam, Mr. Vice President, the tendency may be, or the desire may be, to put into statutory form some of the remedies which currently exist in the common law. But again, I would say that it's not a place that the government wishes to go today. We have well-established common law that deals with the remedies that are available, and I think that those will continue to serve us well. Thank you very much.
Senator Ramdeen.
Good afternoon, Mr. Vice President. Mr. Vice President, as I stand to contribute to this debate on the amendment to the Magistrate Protection Act, I find it very strange to listen to everybody contributing to this debate and talking about how important it is to protect magistrates, how important the magistracy is, how important a job the magistracy does, how we must protect them against all these things that can happen. And at the end of the day, if the government wants to do that, the only senator that I have heard thus far who is, in addition to the opposition, that has really said what the position should be is Senator Seepersad. Because let me put it this way, Mr. Vice President. I know a little bit about this thing called the practice of law. So I've heard over and over that people have said that if you have a problem with the magistrate, you're not taking away anything, so just sue the state. That's the answer, sue the state. Well, I know a little bit about suing the state too. So let me explain something. The magistrate performs many different functions in a judicial capacity. It's a very strange creature of statute. It performs purely judicial functions, and a magistrate performs administrative functions as well in the capacity as a magistrate. So let's take this argument about suing the state. Under the Indictable Offences Preliminary Inquiry Act, there's a provision called Section 25. It says, after preliminary inquiry has been concluded and the warrant of commitment for trial has been made out, the magistrate, hear who? The magistrate shall without delay transmit to the Director of Public Prosecutions the complaint, the depositions of the witnesses, the documents, the evidence, the exhibits, the warrant of commitment for trial, and the recognizances entered into. So let me ask this. When the magistrate doesn't do that, when the magistrate doesn't do it, and somebody has to sue the magistrate in judicial review proceedings, and an order for cost is made against the magistrate, who paying that? Not the magistrate? How are you going to sue the state for that? Who are you going to bring the action against? You're going to bring a constitutional motion for what is properly a judicial review? This law is 101 years old. The Attorney General said so. 101 years ago, they didn't have judicial review. They had something called the prerogative orders. So when the magistrate doesn't do what they're supposed to do, and I have done it before, that's why I'm telling you, you bring judicial review against the magistrate. You can't bring it against the Attorney General. You can't bring it against the state because the magistrate is not vicariously liable. The duty is upon the magistrate to do it. You file judicial review proceedings. The magistrate must come to court and defend it. An order for cost is made. $250,000 to pay. Who paying it? Who is paying it? All of the people who are saying sue the state. How are you going to sue the state for that? Let me give you another example. Under the Summary Courts Act, there's a provision here where notice of appeal has been given in accordance with Section 130, the magistrate or justice shall within 60 days of giving of such notice draw up and sign a statement of reasons for the decision. For those who practice law, everybody knows it's very, very rare that a magistrate produces reasons within 60 days. Having not produced the reasons within 60 days, what do you do? What is the ordinary man that Senator Mark is talking about, who is convicted in the magistrate court, files an appeal, so that remedy is out. For those people who say, we must just appeal, no big thing, just appeal, right? So when the appeal comes up 5 years later, and there's no reasons before the Court of Appeal, during that time, a litigant wants to get their reasons, so the lawyer will know what they're going to argue before the Court of Appeal. How do they get the reasons? They sue the state. For all the people who are saying, just sue the state. So what do you do? How you're going to sue the state for that? The only way you can compel the magistrate to do what the law requires him to do is to bring judicial review proceedings against the magistrate. When you bring the judicial review proceedings, you know what happens? The magistrate will come and produce the reasons. You know what's going to happen after that? The magistrate has to pay cost of those proceedings. Who's going to pay the cost? Who is going to pay the cost? The magistrate will lose the house or the car, right? So let's do this. Let's all of us talk real good about how good magistrates are, right? The magistracy, that's what we come here to protect. But when the time comes, you talk the talk, but you can't walk the walk to do the right thing. Senator Seepersad said it. I know I could read English. When Lord Denning said in this case, Cyrus and Moore came because of Maraj and the Attorney General. He said, in the old days, the Attorney General said it, whatever may have been the reason for the distinction, it is no longer valid. What does that mean? Does that mean, well, it ain't valid. The distinction between lower inferior tribunals and judges is no longer valid. But you know what we must do? The immunity, we must give them three-quarter immunity. That's what we must do. So we allow people to sue magistrates, but you must prove that you have malice or reasonable and probable cause. How that could ever make sense? How could that justify us coming here today and say, well, we are prepared. You know, what we should do, we should give them the same immunity. So what does the same mean? The same means, does a judge of the High Court, like Senator Seepersad said, she says we must give them the same immunity. Does that mean that when we pass this legislation, it's a very simple thing, you know, are magistrates going to have the same protection that are afforded to judges? The answer is no. And if the answer is no, what is the justification for coming here and saying, let us give them protection? Well, what kind of protection are you giving them? I haven't heard anybody stand up and explain how it is that the magistrate who is faced with a cost order, right, is going to pay it. Is going to be at the mercy, the same thing that we're trying to prevent, is going to be at the mercy of the state, right? The Attorney General said in the case that was before the court, the Jagru case, it leaves open the opportunity, Attorney General, for an Attorney General to be able to say, I'm not paying it. And when they say I'm not paying it, then who's going to pay it? Why I'm giving you these real-life examples, or giving everyone these real-life examples, is because we will make a fool of ourselves to sit down here, have a debate, talk about protecting magistrates, and tomorrow morning, Ramdeen will sue a magistrate, get an order for costs, and the magistrate have to pay it. I have the chief magistrate before the court now, the former chief magistrate. The Attorney General will tell you, confirm with a judgment on damages for $300,000 in one case. That's one. It have about 18 behind coming. You know why? Because the law was set up where, just like Senator Vieira said, the magistrate was doing the best she could have done in these circumstances. There was no place to put young people who were subject to the provisions of the Children's Act. The magistrate was sued. The Attorney General was sued. It's up to me to decide whether I want to go after my damages from the Attorney General, or I could go and take the magistrate house. It's as simple as that. It's as simple as that. And this, the law, as all of us, everybody who has spoken, the opposition, the independent, the government, we are all here to try and provide protection for the magistrates. So why are we giving them a half-baked piece of protection? Mr. Vice President, let me give you an example, an experience. Everybody's talking about the experience. Let me tell you what happened in this country. About 8 years ago, the magistrates in this country didn't pick up on the fact that they could have, when you pass a consecutive sentence, so you hear people charged with 4 offenses, they get 3 years by 3 years by 3 years by 3 years, and they say all to run concurrently. You know the magistrates in this country didn't realize that there was a limit on how much jail you could give people if you run sentences concurrently. You know what happened after that? Every Tom, Dick, and Harry who had a consecutive sentence started to go to court and sue the state. Habeas corpus, false imprisonment. You know what happened after that? The state had to pay out for all those orders that had been made. You know what happened? People were incarcerated, the same people that Senator Mark talking about. People who could have only been sentenced to 3 years were serving sentences for 8 years, 9 years, 10 years. And you know how bad it was? It was so bad that the president, for the first time in this jurisdiction, had to exercise powers under the Constitution and do a presidential order to remit all of the sentences. It was about 200 people, you know. About 200 people in jail serving unlawful sentences because the magistrate didn't pick up, honestly, didn't honestly believe, right? Made a pure innocent mistake to jail people, right? A purely innocent, no malice, no lack of reasonable and probable cause. You know what they had to do? The president had to issue a presidential order for about 200 people. Remit all the sentences that were ordered to run consecutively, to run concurrently. So the person who sit down and make innocent jail for 2 years, 3 years, 4 years, don't worry with them. No big thing. Don't study that. Protect the magistrate. This is about striking a balance between providing protection to a judicial officer who is entitled to that protection. Nobody is denying that the magistrates are entitled to that protection. But you have to understand that if we are going to do that, why go halfway and do it? I sat down and studied this thing. I want to understand what's the policy of the government. The policy of the government is obviously a noble one, which is that they've come here, they've looked at the legislation. Watch. Let me give you a simple example of this. Everybody talk about this case, Jagru. You know what the Court of Appeal was saying in Jagru? Why the Court of Appeal in Jagru didn't say we should amend the legislation? Why the Court of Appeal didn't say that? The Court of Appeal was expressing the view that what they had a problem with was not the legislation, you know. What they had a problem with was the fact that magistrates were being held personally liable in a case where there was no malice. They were acting outside their jurisdiction, and they made an error. So how do you correct that? Do you take away the right of someone, as the law presently stands, and I want to get to that in a minute, or do you provide the protection that the Court of Appeal was focusing on? Justice of Appeal Narayan in Jagru said we must express our concern for the position in which a magistrate is held personally liable for his actions while presiding on the bench. So, Mr. Vice President, let me ask you this. Let's ask the rhetorical question. When we pass this piece of legislation, can a magistrate be held personally liable for something he has done while acting in a judicial capacity? Well, those who want to vote for the legislation will obviously say, yes. Sorry, no. Which is obviously wrong. Because a magistrate can still be held personally liable in these circumstances. And if you bring judicial review proceedings against the magistrate, he can still be held personally liable. You know, the Court of Appeal was, what the Court of Appeal was talking about is that they don't want these officers, these judicial officers, who are performing a judicial function, who are doing public duty on behalf of the state for all of the citizens of Trinidad and Tobago, to be held personally liable for something they're doing in the performance of their duty. So are we satisfied here with what is presented to be able to say that a magistrate will not be held personally liable? So after we pass this legislation, we're not going to find any Jagru judgment again. Correct? We're not going to find any Court of Appeal judge saying this is the position. Correct? The answer is no. Because tomorrow I could sue a magistrate, he will come before the court. If he's lucky, the Attorney General will give him representation. If he loses, he has to pay. That is what this is about. It's about who is going to pay. That is what this legislation is about. The Honorable Minister of Agriculture just talked about what is the mischief? Well, ask yourself, what is the mischief? Is the mischief that we will let them pay in some circumstances? That is what the legislation is doing. So the opposition is not here to oppose the government on this. I understand what the position of the government is. I think, like I said before, it is a noble intention to provide the protection. But why has the Attorney General said to us, let us provide the protection? They are entitled to the same protection that judges of the High Court are entitled to. A judge of the High Court, by virtue of public policy, by virtue of the common law, I have to disagree with the Minister of Agriculture, because it is clear from Cyrus and Moore that the Minister of Agriculture for this one's time was incorrect. The common law never provided absolute immunity to a justice, or as we call them, a magistrate. Never. It never happened. That was never the law. Since 1613, in the judgment of Lord Denning in Cyrus and Moore, the law has always been at common law that justices do not have that protection. They don't. Marshall C's case, 1603. And therefore, what the law sought to do is to incrementally provide that protection by statute. And when you look at the Principal Act that we are being asked to amend, Mr. Vice President, you will understand how that came about. The Principal Act that we are asked to amend, which is the Magistrate Court Protection Act, is littered with provisions that provide protection to the magistrate in every single clause. Yeah, right, thanks. So let me, with the little bit of knowledge that I have, let me explain how this thing operates. Section 4, like Senator Hussain says, I think he was quite correct in what he said. Section 4 tells you if you are going to sue a magistrate, the basis upon which you have to advance to sue the magistrate. So there are three things that you can do. You can allege he acted without jurisdiction, he acted maliciously, or he acted without reasonable or probable cause. The big debate that we are having here is really what happens with relation to Section 5. As the law presently stands in Section 5, where you allege one of the grounds in Section 4, the law provides that if you allege the magistrate has acted without jurisdiction, you do not have to prove that it was done maliciously or without reasonable and probable cause. It's very clear. That's what it says. Maintain an action without. That is what without means. You don't have to do it without alleging that the act complained of was done maliciously and without reasonable. So how can you possibly say that as the law stands, you can bring an action? An action is something in property, you know. The right to bring an action is called a chosen action. It's a right of property. So you have the right now to bring an action, and the elements of that action do not require you to prove malice or the absence of reasonable and probable cause. You come now with legislation that says if you want to sue the magistrate, you must prove those things. So how can you possibly say that I'm not taking away, right, the fact that you don't have to prove those elements now, and when if this law passes and you want to sue the magistrate, you must prove malice and you must prove reasonable and probable cause. Is either something is wrong with me in not being able to read it properly, but I'm sure I'm right. Now, why do we want to do that? Why do you want to place the burden? Everybody talks about JAR group, right? So while we're concentrating on protecting the magistrate in JAR group, which is what Justice of Appeal Narayan said we should do from personal liability, what happens to the person who gets locked up without any jurisdiction, go and sit down in the women's prison for 5 months, right? He must sue the state. How? How come everybody's sue the state? But sue the state how? You know, there's a way these things are done. You don't just go to court and say, I want to sue the state. You have to bring a claim, right? If you come in judicial review, you must not have an alternative remedy, right? You don't just pick it up and decide, I'm going to sue the state just so you know. It don't operate like that. It doesn't operate like, you just can't come and say, well, you can't sue the magistrate, so just sue the state. The whole purpose since 1977 to now, what has remained the law from 1977, the most famous case in public law, Maraj and the Attorney General says, not every error of a judicial officer you can bring an action for. So there will be cases where a magistrate will commit an error which you cannot bring an action because despite what we are being told, you know, the vicarious liability doesn't apply in the case of a magistrate. A magistrate is not a servant or agent of the state. So this concept that you could just sue, just like that. You just pick up yourself and sue. Well, for those who know a little bit more about how you bring an action against the state, you have to establish liability first. And a magistrate is not a servant and or agent of the state, so the Attorney General will tell you that the State Liability and Proceedings Act doesn't apply, so that's why you can't sue the state for everything that a magistrate does. So, for those who are prepared to allow the magistrate to lose their house, lose their car, lose their savings in the bank, you can all well be happy, go merry, go lucky, and support this legislation as it presently stands. The opposition has not come here today to oppose the government. We have proposed a clause that will capture any claim that is brought against any magistrate, whether it be in private law for false imprisonment, whether it be in public law for judicial review, whatever claim is brought. You can bring an action and ask for a declaration that a magistrate has acted unlawfully. That doesn't mean that the magistrate is going to get, that you are going to get damages against the magistrate. But what about the order for costs? When the magistrate is saddled with a bill for 200,000 or 250,000, who's going to pay that? We had a magistrate who went all the way to the Privy Council, the chief magistrate went all the way to the Privy Council. The Attorney General will tell you that, Sherman McNichols, Lord rest his soul. He went all the way to the Privy Council to challenge disciplinary proceedings by way of judicial review. When he reached the Privy Council and he lost, who's saddling the bill? The state? When he lost in the High Court, the Court of Appeal and the Privy Council, and the bill is almost 1.5 or 2 million, who's going to pay that bill? This doesn't protect him. I can tell you that. So if something happened to a magistrate tomorrow, and somebody brings an action against them in judicial review, this will protect them. So we can all be comfortable and happy, all of us, and support the legislation because we think it sounds good. But when you actually have to put it into action and see how it is going to work, right? When orders are made against magistrates, right? And a magistrate who is working, like all of us have said, magistrates could never be paid enough for the work that they do. If you go to the San Fernando Magistrate Court now, in the old Magistrate Court building, you have a senior magistrate sitting in a court without air condition in 2018. With the fan working sometimes, not working sometimes. They don't even have a proper office to work from. And then when they saddle with that burden to carry, what we do? We sue them. And what we do? Let's put it a different way. Let's put it in a more honorable way. They will rely upon the Attorney General, whether it be the Honorable Faris Al-Rawi or anyone else, at their discretion, to decide whether they will foot that bill or they won't. You think that is right, Mr. Vice President? You really think that is where we should be heading? Does that compromise the independence of the judiciary? Of course it does. And why all of us are speaking about these international treaties and Latimer principles and independence of the judiciary and the Constitution? At the end of the day, the simple fact is, if these things are so important and the independence of the judiciary lies at the core of upholding the rule of law, Section 1 of the Constitution says Trinidad and Tobago is a sovereign democratic state. And an essential element of being a sovereign democratic state is an independent judiciary. The Attorney General has told us the magistracy is the lower arm of the judiciary. So since it's so important, and its independence of the judiciary is so critical to upholding the rule of law and the Constitution, it's so important for us all, we give them a title 3/4 of the way. No problem. We must uphold the rule of law 3/4 of the way. We must uphold the Constitution 3/4 of the way. That's good. That's what we're prepared to do. As the Minister of Agriculture said today, we're prepared to go so far today. So I don't know. It's probably, that's the way we run our democracy. We have 90% rule of law, 80% upholding the fundamental rights. I mean, really? Really? If the independence of the judiciary is the core of the Constitution, for every single one of us, for every citizen of Trinidad and Tobago, 1.3 million of them, when we come to decide whether we should put things in place to ensure the protection of the judiciary, we say, well, you know, they had a politician in this country one time used to say, well, you're here all tonight. So as we hear today, we're going to do so much today, and we're going to leave the rest for tomorrow. We're going to complete the independence of the judiciary completely some other time. We're going to start. We're going to do something. We're doing something about it. So while we're here, 75%. We're good to go. Mr. Vice President, this is not how our democracy operates. This is not how a serious government operates. What the government is doing, we are supporting them. But let us do it the right way. Let us make sure that when we leave here tonight, if you meet a magistrate tomorrow, they will be able to say thank you for what you have done for us. We understand what you all have done. You all have protected us. And they are when they, like Lord Denning said, when they sit down to write their reasons tomorrow or to find somebody guilty or to find somebody not guilty, their fingers wouldn't be shaking. They wouldn't have to worry about, a man, Representative Ramney might sue me, you know, let me best let he go, you know. It doesn't operate like that. We cannot have a sword hanging over the head of any of our judicial officers. They have taken an oath to dispense justice without fear or favor, affection or ill will. Let us put the circumstances in place to ensure that when they dispense justice in those circumstances, that they can be free from any influence, fear or favor, to be able to do that. And why I still stand here to contribute and don't understand why we are saying they must have the same protection as the upper judiciary, the Court of Appeal, the High Court, and yet still, anybody who votes for this legislation this afternoon, if they're honest with themselves, will be able to say, yes, they support the legislation, but will also say, no, the magistrate doesn't have the same protection as a High Court judge. Why? Why did the Attorney General read out what Lord Denning said, right? That wasn't the only thing. We are going to go down this road now, about what is within jurisdiction and what is outside jurisdiction. Whether you're acting, whether you have deprived yourself of jurisdiction for one thing or another. One of the cases that the Attorney General cited, one of these Court of Appeal judgments, they referred exactly to that, about how do you get to the point where you exercise your jurisdiction and you deprive yourself of jurisdiction. So, I don't think, Mr. Vice President, that we are being fair to the magistrates that we have come here to proclaim that we have come to do something that gives them the protection that they are entitled to. Not that anybody is doing any favor for them, Mr. Vice President. They are entitled to that protection. And we should do our duty and be able to give them the protection that they are entitled to. And if we are prepared to do that, then we will support the amendment that has been proposed by the opposition with respect to this matter. Mr. Vice President, all of the cases that the Attorney General has spoken about that have been decided in this jurisdiction, all of them, what happens to those persons who are on the wrong side of the order of the magistrate. What happens to them? They will now have to climb an insurmountable hurdle to be able to bring an action against a magistrate. When the law, for 101 years, the law was that you don't have to do that. We have decided today, after 101 years, to make it more difficult for those persons. Well, I don't know that I want to support that position, Mr. Vice President. I want to support a position that does what everybody here seems to say we should be doing, which is that we should provide the most protection that we can. We have an opportunity here today to do what the law has not done for 101 years. Why don't we grab that opportunity with two hands and take full advantage of it, government, opposition, and independent, and be able to say that, yes, magistrates are entitled to that protection. Mr. Vice President, every single case that the Attorney General has cited, the Attorney General referred to this House of Lords decision in Reem Maxia Minor. And you know what Lord Templeman had to say? What Lord Templeman had to say? Sorry, I apologize. This appeal demonstrates that the time is ripe for the legislature to reconsider the liability of a magistrate and the rights of a defendant if an unlawful sentence results in imprisonment. There is no liability on a judge of the High Court acting as such, and no right for a defendant to damages for an unlawful sentence imposed by a High Court judge. Harm may be prevented or cut short by bail and an appeal procedure which results in the sentence being quashed. On the other hand, a magistrate is personally liable where an innocent error of law or fact results in an unlawful sentence of imprisonment imposed without jurisdiction. So we are fighting up with this idea of what is within jurisdiction and what is outside of jurisdiction. But because the law is 101 years old, and at that point in time when the law was passed in 1917, there were certain things that you could not do in law then that you can do now that affects the liability of a magistrate. And my main concern in propounding and supporting and putting forward the amendment is that the Magistrate Protection Act did not, at the time it was conceptualized, or could have at the time it was conceptualized, foresee all of the liabilities that could have resulted in a magistrate being personally liable. It couldn't foresee what could happen in judicial review proceedings. And therefore, while we have the advantage 101 years later to be able to foresee things that couldn't be seen in 1917, why should we not take the advantage of curing the defects that are there now? Section 5, Section 6, Section 7, nobody has referred to the fact that Section 13 of the Principal Act that we are asked to amend provides protection to the magistrate to the point where if you can prove, and in one of these cases, the case that Justice Barrow decided, the Carville case, you know what was the problem in that case, Mr. Vice President? No, not Carville, sorry. There's a case called Ricky Sagram and Magistrate Marcia Air Caesar, an old case. The HCA number is 299 of 1997. A very, very, very good judgment of Justice Jamadas. He was that first instance. You know why the woman who was to become the chief magistrate was held liable here for? Because in the action that was brought against her, by virtue of a technicality, she didn't prove that the person who she sentenced was convicted for the offense. Pure technicality. She was held liable. Damages to flow. So, do you want a repeat of that? Will the magistracy be satisfied when we leave here tonight to be able to say we've done justice to them? No. If we pass the legislation as it presently stands, as proposed by the government, the answer, there will be a cry of no by the magistracy, the most important people we are here to protect this afternoon. if we pass the legislation as presently constituted, there'll be a cry by the people who are affected by orders made without jurisdiction, because the door is virtually shut on them to have resort to the court. So they would be crying no. But if you do what we ask, which is to cover all orders made by a magistrate, make them immune from any order with respect to damages or with respect to costs, you have a yay from the government, the opposition, the independent, the magistrate, and the population. What is difficult about that? Why would anybody have an argument against doing that? Why not allow those people who have the right of access constitutionally guaranteed by Section 4B of the Constitution to go to court and sue anyone who they consider has infringed their right, whether it be in tort, whether it be in contract, whether it be under the Constitution, whether it be in judicial review? Why do you want to hinder that right by placing a legal burden that is virtually insurmountable, when you can allow those persons to have that right made effective, given to them under the Constitution? I'm obliged, Mr. Vice President. Given to them under the Constitution, allow them to continue to exercise the right that they've had for 101 years. This was a very carefully drafted piece of legislation because it took into consideration the fact that you can bring an action if a magistrate is acting outside of their jurisdiction, and you can bring an action if a magistrate is acting intra vires as well. And therefore, why not take the opportunity to leave the law as it presently is? Where in any of this have there been any criticism of the act? Not the result of the act, you know. The act. What has been criticized is the result of the act. So we can cater for that. We can cater for that by letting the state take up the bill where someone has been wronged. It's not like we're opening the floodgates. Someone has been wronged. They are entitled for that to be put right. Whether it be put right by a declaration of the court, whether it be put right by an order for damages, whatever it may be that right that that person simply wants to exercise, to hear that they were either right or wrong. The protection of the law that allows access to the court is not about going to court to win, you know. It is about the confidence that you have in the administration of justice to be able to access the court, whether you are successful or not. It is that is preserved under Section 4B. And therefore, in those circumstances, Mr. Vice President, I feel very strongly about this, and I call upon all the senators here, independent, opposition, and government, to do justice to those people who go out every day in the far out regions of our country, Trinidad and Tobago, whether it be in Scarborough, whether it be in Point Fortin, whether it be in Rio Claro, whether it be in Princestown, whether it be in Arima, it doesn't matter. They do public service to an extent that we cannot comprehend. The sacrifice that they make, the Attorney General, if you divide the number of cases, he says, by the number of courts that they have, is almost 10,000 cases per year. Their job is an unenviable one. Sometimes they do more than a high court judge in terms of the discharge of their duty to the public. And why should they be given any less protection? We are here, we are prepared to support legislation that provides an absolute immunity, which is what the law calls for in relation to officers of the magistracy, and bring them on equal footing with officers of the superior judiciary of the High Court and the Court of Appeal. For those who are prepared not to go to that extent, you are doing an injustice to the magistracy. We have proposed an amendment. Perhaps the Attorney General might want to tweak it, but we have proposed an amendment that provides an absolute immunity, that as this legislation is passed, proclaimed, and assented, no magistrate will ever have the fear when they exercise their judicial function that it will ever be at an unfair cost to them. They deserve no less, the members of the magistracy. And today I ask the Parliament to not give them less than they deserve. I thank you, Mr. Vice President.
Honourable Attorney General.
Thank you, Mr. Vice President. Mr. Vice President, I thank honourable senators for truly deep and reflective submissions. I thank Senator Ramdeen for his very stirring fulminations, because I share a lot of his concern. Indeed, we've been speaking about this during the course of this afternoon. We have a few issues, in essence, before us this afternoon. The opposition says, commendably, let's go the whole distance. Why not now? Why not put two hands upon the protection to magistrates? Indeed, that's a very genuine question which can be addressed by considering where we are right now. So we stand here on the 11th of December 2018, 101 years away from the 1917 law, the Magistrates Protection Act. We know, as Senator Choate reflected, as I gave in contribution, as others have, that international bodies, in particular the Commonwealth Association, have given us exhortations as to what we really ought to consider. And we do know that our court has, in fact, reflected in the Jagru matter a little bit further than Senator Ramdeen asked us to reflect. I don't think that Senator Ramdeen was deceiving us in any way at all when he read the dicta of Mr. Justice Narayan at paragraph 28 of that judgment. But the qualifying words that were left out, I think, are material in answer to his submissions today. Not that I disagree with the substance of the submission, but I want to explain why it is I respectfully think that we can't agree to it at this point. You see, it wasn't, as Senator Ramdeen put it, that the judge said, however, we must express our concern for the position in which a magistrate is held personally liable for his actions while presiding on the bench, which is where Senator Ramdeen stopped in the quotation. The judge went on to say this: in a situation where he has acted without or in excess of jurisdiction, but without malice of any kind. And Senator Ramdeen's position was that it wasn't that the judge was asking the judiciary to have a view of this. That's what he said. He said the judge was reflecting, Mr. Justice Narayan, Justice of Appeal, was reflecting upon the odium which we ought to have in the magistrates being unprotected, as he put it, simpliciter, but which I've gone further by quoting the text correctly to add where he has acted without or in excess of jurisdiction, but without any malice of any kind. But it's not correct to say the judiciary did not ask us to have a view of that situation, because this is what the judge says further. And I quote, the injustice that may arise in such a case, and that's the specific case, and the need for legislative intervention was recognized by the House of Lords. And they go on to look at the case of McSee versus Mullen. You see, the judge then went on to quote that the appeal demonstrates, and is using the language of Lord Templeman, and I think specifically so, as an invitation to the legislature to take note. Because he quoted, and this is Mr. Justice Narayan as follows at paragraph 28 at page 11, this appeal demonstrates that the time is ripe for the legislature to reconsider the liability of a magistrate. And the judge ends there. So I don't think that there was not a specific invitation to treat with the exact case of the limitations of sections 4 and 5. I think this is exactly what our Court of Appeal was telling us to do, an invitation to the legislature. in trying to agree with the substance of what Senator Ramdeen has offered, but in drawing a distinction as I do now, I'm compelled to say this. The opposition says to us today, 75% of the law should be upheld, 80% of due process should be upheld. The opposition is willing to do this 100%. I have in my hand a letter from Alam Chambers, Monday, 19th February 2018, addressed to me. It is written by Rajiv Prasad, attorney at law. And the attorney at law is writing me specifically in relation to the case of Mason versus Magistrate Indar Jagru. And here are the words. Senior counsel Mr. Sinath Jairam and I have been briefed by your good office, that is the Attorney General's office, to represent His Worship Mr. Indar Jagru, the defendant in the caption matter. Magistrate Jagru has been sued in his capacity as presiding magistrate for the Arima Magistrates Court for having committed the claimant to prison in circumstances where the claimant is contending that the magistrate had no jurisdiction under the Children's Act. The matter is now before Court of Appeal after Justice Rajkumar found against the learned magistrate. Hear these words. We had written to your predecessor seeking to have a decision made in relation to the provisions of an indemnity to protect the learned magistrate. To date, that's February 2018, we have not had a response, and we have been advised by those instructing us that another letter should be prepared and directed to your office renewing our request on behalf of the client. So the UNC's exhortation today, 75% is not good enough, 80% is not good enough, but they clean skip over the fact that for the full time that they were in possession of the legislature and driving agenda as a government, not a thing was done to even go from 0%. Now, that's a bit churlish to stop the argument just there if it is coming from me in answer to my learned colleague who has made a good submission. So let's go a little bit further. Because that point really says, don't come and tell me, quote unquote, the government, that this is not good enough when you couldn't do anything about it at all. But let's explain why we have come in this fashion at this time. The indemnity, the sanctity, and the privilege against suit that the judiciary in its higher echelon enjoys, that's the High Court and Court of Appeal, is not to be found in any Magistrates Protection Act and a similar word for the judges. It is to be found in the common law of Trinidad and Tobago. And I ask the question now, what is there to stop a judge at law from being sued for exactly the circumstances Senator Ramdeen just offered? Where the magistrate's house jumping up, car jumping up, and personal liability jumping up. Where is there a single codified statutory provision that grants immunity for the judiciary in its higher branch, the Superior Court? We have the legislation for the Inferior Court, which we are now dealing with today. But what stops, most respectfully, the judiciary from being subjected in the Superior Court to the privileges in Section 14 of our Constitution? Let me remind honorable members what Section 14 of the Constitution is, because Senator Ramdeen is right. The Judicial Review Act did not exist in 1917, and there's exposure there. But when we look at Section 14 of our Constitution, which did not exist in 1917 either, let's look to what that says. Section 14 of the Constitution says this. It's under Part 5. For the removal of doubts, it is hereby declared that if any person alleges that any of the provisions of this chapter has been, is being, or is likely to be contravened in relation to him, then without prejudice to any other action with respect to the same matter, which is lawfully available, that person may apply to the High Court for redress by way of originating motion. Subclause 2. The High Court shall have original jurisdiction to hear and determine an application made by any person pursuant to subsection 1, and to determine any question arising in case of any person which is referred to in pursuant to subsection 4, and may, subject to subsection 3, make such orders, issue such writs, and give such directions as it may consider appropriate for the purpose of enforcing or securing the enforcement of any of the provisions of this chapter to the protection of which the person concerned is entitled. Subclause 3. The State Liability and Proceedings Act shall have effect for the purpose of any proceedings under this section. Let me translate that for non-lawyers. Section 14 of the Constitution allows the High Court the privilege to fashion any order or remedy against anybody, including judges of the Superior Court and Inferior Court, such that the house jumping up, the car jumping up, and there's personal liability. That's the law. That's the supreme law of the Republic of Trinidad and Tobago right now. Let's go further. What does the State Liability and Proceedings Act say? Which is what I just read from the Constitution, that said that that fashioning of remedy, that the High Court could come up with anything to fix a constitutional wrong, any remedy it wants. And I dare say, including the type of prejudice that Senator Ramdeen so vividly described. What does it say? It says the State Liability and Proceedings Act shall apply. So let's go to that. Section 2 of the State Liability and Proceedings Act, Chapter 802, and Act 17 of 1966, says this. Subsection 2.2. Servant in relation to the state includes an officer who is a member of the public service and any servant of the state, and accordingly, but without prejudice to the generality of the foregoing, includes a member of the state, a minister of the state, a member of the armed forces of the state, a member of the Trinidad and Tobago Police Service, hear these words, but does not include the president, any judge, magistrate, justice of the peace, or other judicial officer. What does that mean? The prejudice and risk from an intellectual point of view, wearing a veil of justice as we do now as legislators, is that the risk of the magistrate, described so vividly by my learned colleague and so capably by him, Senator Ramdeen, is the same as a judge, save for the application of the common law. Now, what did we do as a country in our legislative history to treat with this? Let's use the example of the immunity from suit for barristers. Lawyers are permitted, or have been, and now it's subject to some evolution, a privilege against suit whilst you're at the bar. You could sue the solicitor for negligence, but the barrister on his legs at court was given a privilege and immunity against suit. England is sort of tweaking with that right now. Where did that exist prior to the Legal Profession Act, when we fused our profession? Strictly in the common law. What did the country do? In coming up with the Legal Profession Act, we took some elements of the common law and we codified it in the Legal Profession Act to grant that immunity and privilege. So let's go a step further. What is the government doing? Why not take advantage of the proceedings, of the procedures recommended by Senator Ramdeen? Let me explain why most respectfully, Madam President. Because there is a genuine need for us to take a whole of judicial officer perspective and codify the position. And respectfully, after 5 years and 3 months of governing this country, I'm not comforted to hear from the UNC today to say, do it now on the back of an amendment we propose now. Why? It's the same bench that says, please consult, show us evidence of consultation, make sure people agree. Whilst I like the idea, as the Prime Minister says to me all the time, you, sir, as Attorney General, do not legislate for yourself. you legislate for the country. And therefore, I did step outside, call the consultative arms of the judiciary that I could reach, speak to the president of the Law Association, speak to Mr. Jairam, senior counsel, who did the Jagru case, etc. And suffice it to say, there are conflicting points of view as to how far we ought to go right now, which requires us to make sure we get it right. And in doing that, this government has taken an approach. We are prepared to move the Parliament any day, any time, and continuously to come back to issues that we can't do in one haul. In other words, we just start. For 101 years, these magistrates have been left unprotected. But this Attorney General, who pushed this particular amendment, went out to get the amendment done, did the consultation to get it done. We made sure to do this because how could we, in pushing the magistrates into a criminal division and traffic division, in putting magistrates into the children's court, in putting in the criminal proceedings rules, how could we leave that level in such an unsatisfactory state? What we can say as a government is that the whole position is being looked at, because you know what has not been said today? There are anomalies with respect to masters as well. So I'm going to do magistrates today, ad hoc, judges tomorrow, in codified legislation, and masters otherwise. Let me explain why we're going further. The Cabinet is considering right now recommendations from the Attorney General to enlarge the sphere of operation of the magistracy, in particular by adding on judicial support officers, judicial research assistants, and having the JLSC make these appointments, so that the work in the magistracy can be improved. Those of us that have practiced in the civil courts know the civil courts work well because they have the administrative structures to work well. But a magistrate can't function where it's just the chief magistrate and the clerk of the peace running the administration of the magistracy. No administrative officers, no qualified legal personnel, as Senator Hussain recognized. You see, what we have done is to take the management of the judiciary into active consideration. So we say respectfully today, there are models of law that are very appealing to the government. And I'll read one. I find the Bermuda law to be particularly interesting. This is their Magistrates Act 1948, mind you. And hear this, scope of magistrates' immunity. 10A, subject to this section, a magistrate shall be immune from any personal civil liability in respect of his judicial acts, whether within or without jurisdiction. I love it. Blanket civil immunity, the mischief being a tort, the way you could pay out of your pocket personally. Subsection 2, nothing in subsection 1 shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, including appeals, applications for judicial review, and applications for redress under Section 15 of the Bermuda Constitution. Read that as Section 14 of the Trinidad Constitution. Subsection 3. The common law rules governing the criminal liability of superior court judges in the exercise of their judicial functions shall henceforth apply to any magistrate when acting in judicial capacity. Meaning, take what prevails in the High Court jurisdiction as it relates to criminal liability and apply it here. For the purpose of this section, magistrate includes justice of the peace and any person appointed to sit as member of a special court or required by law to carry out any other judicial function. This is the model of the law that is appealing to the government. Are we in a position today to legislate that? No, we're not. because I have yet to map out the special courts, as Section 24 of the Criminal Division is now in force and allows. I have yet to figure out the incongruities in a short space of time with the space of the masters as they come to case manage, in particular as we are recommending that the masters do sufficiency hearings and initial hearings when we propose the abolition of preliminary inquiries. We also have to look at the codification for the judiciary itself in the superior courts, meaning High Court and Court of Appeal. So where are we today? Perhaps we are indeed at the position where we're saying 75% is a good start, or 80% is a good start. Because it is more important that we do something now whilst we map that out and don't wait. And let me give you an example of the government's commitment to this. Senator Ramdeen has made, in the course of several of our debates, some very important discussions that we undertook to come back to. You will see in legislation to come this week and next week those commitments and undertakings fulfilled. In other words, then, we're prepared to do the work whilst we do what we can do now. I come back to my exhortations last week in recommending to the Senate, as Prime Minister Motley said, stake and claim the ground you have now. And what I am humbly recommending to honorable members is that, bearing in mind the limitations that the government has expressed today as to why we can't go the proverbial full distance, Robert, why we can't go the proverbial full distance, the position that we're having right now is this is what we can do immediately. And we are going within the parameters of the Jagru decision, because it wasn't just that the judges said in the Court of Appeal, go the whole distance. They were speaking specifically about exactly the type of formula that we have applied here today in this bill. Senator Vera has circulated a very interesting, let me call it good-looking amendment, proposing a similar formulation of words as we have for the, in other laws where we have protection. Public procurement, was it, Senator Vera? There were two other models, data protection, was it? Data Protection Commissioner. Where Senator Vera has proposed that there be the good faith formula as opposed to the bad faith formula, and that it include the permutations and not just the acts, the steps taken in preparation, the other elements that can come into effect. I think it's a laudable position, but there's a marked difference right now between good faith and bad faith, and who has the burden at what point in time in the progress of the matter. The recommendation for bad faith is because the bad faith without probable cause or reasonable cause is a higher standard than the good faith standard. So we've erred on the side of the higher standard. I accept what Senator Ramdeen is saying. I think that Senator Ramdeen is on the point of genuine acknowledgement of risk. Senator Ramdeen is correct. The magistrates do have, under the JR aspect and the exposure for costs aspects, in the individual application of laws, be it preliminary inquiries or committals, etc., there is that risk. But there is also the same risk for the judges right now. And what we say is, give us the room to come back to this issue, because there are other parts that are moving in this machinery. Masters, judges, equally so magistrates, and specialist courts. Don't we have an obligation to courts of superior record, like the industrial court, to think about what they are doing? Don't we have an equal poise to hold for superior courts, such as the Environmental Commission, Equal Opportunities Commission? So the point is that in the round, it makes sense to legislate one law that treats with all of this. It's something that we certainly intend to advance as we move along. But most importantly, whilst that grass is growing, We could not have the horse that is the magistracy bearing the load of Trinidad and Tobago for the 140,000 cases per year that they do, bearing that load without at least leveling up the protection to the rest of the judiciary. Because all that the superior courts of record rely upon is the inherent jurisdiction, the common law. So, honorable senators, it's a fighting chance. It's certainly a far cry better than having done nothing for the period 2010 to 2015. It is an ability to at least take us part of the way. I want to thank Senator Ramdeen for putting on record in this Parliament his thoughts and positions, because there is merit in his submission. I most respectfully cannot recommend that the government accept the invitation to today make this amendment, because the government still has some homework to do to get it right. But I want to thank Senator Ramdeen for putting the observations on the record, and I take it from a genuine position of trying to better the position that Senator Ramdeen has in fact made those submissions. Senator Choate has correctly observed the Latimer principles and the facts that we need to observe in getting here. In fact, it's part of the material that I digested and referred to in piloting this bill. I ask honorable members for the opportunity to continue the work of protection, partly today in committee stage, and then partly when we propose to return to this issue in what I think really ought to be an omnibus provision of protection. Madam President, I look forward to the committee stage of this bill, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause.
Clauses 1 and 2.
Honourable Senators, the question is that clauses 1 and 2 stand part of the bill. Honourable Senators, the question is that clauses 1 and 2 now stand part of the bill. Senator Ramdeen.
Thank you, Madam. Thank you, Madam Chair. Oh, 1 and 2. Sorry. One. Sorry. Yeah, sorry.
Honourable Senators, the question is that clauses 1 and 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Senator Vera has circulated an amendment to clause 3.
Yes.
Yeah. Senator Vera.
I spoke with the Attorney General earlier, and he has repeated what he told me, that government's intention is to have one law that treats with all equal opportunities, EMA, judges, industrial court, masters. That would be ideal. My amendment was born out of the concern that the clause as drafted covered sins of commission, any act done by the magistrate, but it might not have covered the magistrate's refusal or failure to act in a certain way or to make a particular order. Having said that, while the ideal is to have absolute protection for the magistrates, and that was the potential gap I was trying to close, I would not like to see this bill derailed or delayed unduly, because any amendment would mean going back to the other house and then coming back here. So I really do think in terms of the need to shore up this potential vulnerability on the part of magistrates, I am prepared to take the Attorney General's representation, the government's representation, that further legislation is coming that will close it off. And on that basis, given the urgency to protect our magistrates, I withdraw my amended proposal.
Madam Chair.
Just 1 second.
Madam Chair.
Just 1 second.
Oh, sorry.
So, Senator Vera, you're withdrawing your proposed amendment to clause 3.
In the circumstances
So the
indicated.
amendment is withdrawn.
Madam Chair, I wish to raise something before Senator Vera withdrew.
Well, he has withdrawn it, Senator Obika.
No, but if you allow me to just state it then, just for his consideration. Senator Vera said that the bill has to go to the other place for amendments. It has not as yet arrived at the other place. So therefore that doesn't apply. So that fear that he has of it having to go to the other place does not arise at all. So to ask him if he's still strong in his convictions.
Attorney General.
Madam Chair, I thank Senator Obika. I was actually just going to say that myself, but I don't think that cures the mischief. I'd just like to say, first of all, that from the Interpretation Act perspective, the commission includes the omission. So we find some comfort, at least in that point. One would be hard-pressed, therefore, to explain why other laws describe it differently. And what I can say is that the formulae used between drafter to drafter sometimes vary, especially when they're pulling from jurisdictions with comparative laws and they're modeling up. So that could explain why the Information Commissioner or the Data Protection Commissioner had a different formula of protection. But coming from the judiciary's perspective, it certainly is, what we took was what was in keeping with the other. So we went in pari materia to other jurisdictions. But I want to just again say that we are certainly looking at this issue because it's a very live issue right now for the judiciary. And because we're crossing the several hurdles all at the same time, because we have become a very litigious society, and litigation is even more fuel for trouble depending upon how wealthy the litigant is. I don't say that pejoratively or churlishly. The fact is, if somebody wants to commit enough money to causing pain and anxiety to someone, they can. So for that reason, as we have, as a government, furthered the courts of superior record, we really are looking at this in an holistic approach. And I thank Senator Vera for allowing that opportunity. I certainly will be reporting on this as quickly as I can.
Senator Ramdeen.
Madam Chair, to the Honourable Attorney General. Attorney General, would you consider having regard to the fact that a unique characteristic of our jurisdiction is that magistrates perform judicial functions as well as administrative functions, that you add after the words within his jurisdiction in the exercise of his judicial function, so that the administrative aspects of the performance of his duty can still be compelled by a litigant, and the protection that you are seeking to give to him will remain.
Attorney General.
May I ask whether in the execution of his office captures that?
No, because what will happen is that the gamut of powers that he would have or duties that he would have would all be encapsulated in his office. But you don't want to take away from a citizen the right to compel him to do something that is non-judicial. I think your policy is to protect the magistrate in the exercise of his judicial functions. For example, like the example I raised under the Indictable Offences Preliminary Inquiry Act, where he has to do something administrative that you can compel. You wouldn't want to take away the right of someone to be able to compel him to do something not in the exercise of his judicial function, which would be caught by which would satisfy your policy at this point in time, not extend anything that you're doing, but preserve that aspect of it.
I respectfully didn't see it, if I may, Madam Chair, I respectfully didn't see it as actually excluding out the compellability on the administrative side. The government views any act done by him, which includes things which he didn't do as well, in the execution of his office in relation to a matter within his jurisdiction. His jurisdiction is both judicial and administrative.
No, so if you, for example, if he doesn't, right, if he doesn't do something, right, for example, he doesn't forward the notes to the DPP, right, this would prevent someone from bringing an action to compel him to do that. That's the mischief that I'm looking at.
No, the action, as you put quite squarely in your argument, there still is a mandamus availability there. The thing is that we're exculpating him from the personal liability of paying for it. So that stands on its own. We can still compel or go for a declaration. You yourself raised it spot on in your contribution.
No, but you see, the problem with this thing is this word action. We shouldn't be using the word action because I indicated to you we should be, because you can't bring an action. You can only bring a claim, right? And if you bring a claim, right, if you read the legislation and you have to bring a claim, let's take the example of the magistrate who doesn't do his reasons and you have 60 days to do it. You have to bring a claim for judicial review. You go for leave, you get leave. Then you have to bring a claim, whether it be by fixed date, well, in judicial review is by fixed date. So you bring a fixed date claim form, ask for the relief. When you ask for that relief, right, there's a risk that this provision, as drafted as widely as it is here, will prevent that person from bringing that claim, because the only person you can bring that claim against is the magistrate. So what the effect of what we are doing is to deny that person the right to bring that claim, because he can't bring it against anybody but the magistrate.
But we're not barring the bringing of the claim. We're barring the personal liability in respect of the claim.
Well,
no.
AG, I want to agree with Senator Ramdeen on this. Because when you say no action shall be brought, that means no proceedings. Correct. And that would block judicial review and other things. And if, as you say, the mischief you're trying to cure is no personal liability, maybe that's what we should say here. No personal liability shall attach to a magistrate for any act done by him in the execution. Now, that might be a neater and cleaner choice of words, respectfully.
Could you repeat it?
Instead of no action shall be brought, simply say no personal liability shall attach to a magistrate. Partly the wording of my proposed amendment, because I thought that was what we were gearing at. It was all about personal liability rather than proceedings.
Just 1 second, Senator Vero. Yeah.
I don't know if I interrupted. Have you concluded the point? May I reply?
Yes.
Yes? if I look to the wording of for itself and I catch what we're holding on to, which is the potential mischief that someone may not bring an action at all. So first in the act itself, section 3 starts really, every action to be brought against any magistrate for any act purporting to have been done by him in the execution of his office shall be brought in the High Court. So bring it in the High Court. 4, taking away what was there before, which is essentially the writ in every action shall allege the act was done maliciously and without reasonable or probable cause, or done not within jurisdiction, otherwise the writ shall be set aside. So you must come outside of jurisdiction or in excess of jurisdiction, and you must come maliciously. And if you fail to prove that, the magistrate wins. That's what the old 4 said. What we're saying here is no action shall be brought against a magistrate for any act done by him in the execution of his office in relation to a matter within his jurisdiction. Now, the submission that I understand, and please correct me if I've got it wrong, is that this action could somehow be interpreted as Parliament in its wisdom saying, you no longer have the right of judicial review or some form of ancillary claim because there's now a blanket exculpation, right? But 4 is qualified by 5, because subsection 5 is that you can bring an action provided, provided that you cross the hurdle of maliciously and without reasonable and probable cause.
AG, on the plain meaning of the language, no action, well, first of all, 3 says every action to be brought against any magistrate for any act purporting to have been done by him in the execution of his office shall be brought in the High Court. This is not only actions seeking damages.
Yeah.
So if we go with no action shall be brought against the magistrate, when you go in for judicial review, it's against the magistrate. When you go in for mandamus, it's against the magistrate. Inadvertently, we are blocking out the possibility of bringing actions. What 5 is talking about is where the act was done maliciously and without reasonable and probable cause. But then you're burdening my opportunity to go for jail and mandamus.
Madam Chair, so I've crystallized the argument to a potential risk of an implied repeal of other routes and remedies. One of the aims is in fact to discourage action per se, and more particularly personal liability on the civil side. I was just looking at the Bermuda formula, which after describing its first purpose went on to say nothing in the subsection shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, including appeals, applications for judicial review, and applications for redress under Section 15 of Bermuda. That could probably solve what we're thinking about, because it's effectively a notwithstanding provision. Yeah? Yeah? So, Madam Chair, as opposed to causing an amendment to Section 3 in the formula raised,
We'll just add something.
we have the potential to bifurcate 3 into a subclause 1 and subclause 2. And subclause 1 would be the language proposed in the bill. It'll be a Section 4.1, forgive me, and we can add in a Section 4.2, which would read as follows, Madam Chair. Nothing in subsection 1 shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, comma, including appeals, comma, applications for judicial review, and applications for redress under Section 14 of the Constitution. Full stop.
That's it?
Yes, please.
All right, so let me just reread the proposed amendments. Clause 3 will now be Section 4 of the Act is repealed and the following section is subsections are substituted. No, section is substituted. 4.1, no action shall be brought against a magistrate for any act done by him in the execution of his office in relation to a matter within his jurisdiction. 4.2, nothing in subsection 1 shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, including appeals, comma, applications for judicial review, and applications for redress under Section 14 of the Constitution. Yes?
Yes, please.
All right, so honorable senators, I shall now propose the question. The question is that clause 3 be amended as follows. There will now be a 4.1, which is the original clause 4 here, and then 4.2, which will read as follows, and I repeat, nothing in subsection 1 shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, comma, including appeals, comma, applications for judicial review, and applications for redress under Section 14 of the Constitution. Those in favor say aye.
Aye.
Senator Vera.
Thank you, Chair. Through you, if we are going to follow the subsection 2 of the Bermuda legislation, I was just curious why we didn't follow the subsection 1.
Okay, so let me just do a little housekeeping here, please. I took pains to write it down and to read it and propose the amendment. So we are now at the stage of going through finally whether we accept the amendment. But Senator Vera, I will just allow that question to be put to the Attorney General, and I will suspend my my proposal. Attorney General?
Sure. The answer is we're hybridizing the approach. I'm not yet into the personal liability on the civil versus criminal side, because if I do one, then I have to kick in the criminal consequences in pari materia to what prevails in the judiciary, and I don't have that yet. So the mischief that we're looking at for the one is we at least shunt an action but allow for other forms of action, because there's a cost to the action in and of itself if you're acting within jurisdiction and without jurisdiction, but not maliciously. So I think that it makes sense in the round.
Thank you. Thank you.
Honorable Senators, may I now? Yes? Yes. So, Honorable Senators, the question is that Clause 3 be amended as I had previously read. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that Clause 3, as amended, now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clause 3, as amended, now stands part of the bill.
Clause 4.
Honorable Senators, the question is that Clause 4 stand part of the bill. Honorable Senators, the question is that Clause 4 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 4 now stands part of the bill.
New Clause 4.
Honorable Senators, the question is that the new clause 4 be read a second time. Senator Mark.
One signed, one proposed.
Madam,
Yes?
I think I got a bit confused a short while ago.
You're confused?
Yeah.
Yes.
We have a strong objection to 4,
Yes.
and I really thought we were still on 3.
No, Senator Mark.
No, I'm telling you, honestly with you.
But Senator Mark, but in any event, we're now dealing with your new clause 4 as proposed by you.
Yeah, but remember, you are going ahead with 4. That's all.
All right, Senator Mark, I think you know that there has to be some sort of order in the committee process.
Yes.
And therefore, I am going to revisit Clause 4. I'm going to revisit it, but I would ask that having done all that we have done, I would ask you to be brief in your comments and the Attorney General will respond. So,
Clause 4 revisited.
Senator Mark.
Yes, thank you very much.
All right, Honourable Senators, the question is that Clause 4 stand part of the bill. Senator Mark.
Madam Chair, we have indicated that this particular provision compromises the right that currently is enjoyed by ordinary citizens, and the standard that is set, the bar that is set, is somewhat elevated in the amendment that is being suggested in this bill. And we do not support the proposed amendment in its current form, and therefore we would like to ask the Attorney General whether he would consider removing this completely in favor of the new clause that we are proposing to come. Madam Chair, we have a problem with this.
Just one comment, Senator Ramdeen.
Placing a veto.
So I was
Would you consider?
no, it's,
Yeah.
forgive me, Madam Chair. I was first fixed upon what Senator Mark was saying, because what has been circulated as a new clause 4 is nothing of what Senator Mark just suggested. So I was a little bit confused because I saw clause 4 as really just to say where the money is coming from.
No, the new clause 4.
Oh,
The whole one.
so what I have is a list of amendments to be proposed, moved by Senator Ramdeen, but signed by Senator Mark. Is it that one?
No. He's dealing with your amendment.
Oh.
We went back to your amendment. As proposed by you in the bill.
Attorney General, Senator Mark has just made representation based on the clause as set out in the bill, which is before
I
us.
see, because the new clause 4 I have is what is
Yes.
tabled here as new clause 4, so it's not this.
No.
I see, so it's not
We
new
have-
clause 4.
I have allowed the committee to revisit
To
clause
revisit 4.
4
Right,
in
I see.
the bill, and Senator Mark has made his representation.
So is sorry, so now to jump in there, thank you for the clarification, Madam President. The word "or" that appears in the 4th line, is it that?
No.
No.
You want to deal with Senator Mark first? I just have one little suggestion, that's all. If you want to deal with Senator Mark and tonight,
I'm in the
Yes.
hands of the President, of
Senator
the
Mark,
Chair.
can you just very briefly restate your position on clause 4 for the Attorney General?
Yeah, Attorney General, as it relates to clause 4, what we are saying is that this clause takes away or removes a right that currently exists in the original act, whereby an ordinary citizen can take action against a magistrate who has acted outside of her or his jurisdiction without having to prove maliciousness or the action being malicious and without reasonable and probable cause.
Sure.
And we are saying that the standard or the bar has been lifted, and it is very difficult for people to prove malice and this concept of without reasonable and probable cause. So I'm asking you whether you'll want to delete this provision, seeing that you're removing a right that is currently in the existing law.
Attorney General?
Madam Chair, that would be to not take cognizance of the very dicta of our own Court of Appeal and elsewhere that say that magistrates really ought to be protected where they have acted in excess or without their jurisdiction, but have not been malicious in the course. So I would think that we very much want to take the observations coming from as way back as 1907 in England, straight up to 2016 in Trinidad and Tobago, 2018 in Trinidad and Tobago, which say that this is the formula to be used.
No, but Madam Chair, if I may, all that you have referred to, they have always guided us by, one, it must be within jurisdiction, it must be within their jurisdiction, and even if it is based on malice or with reasonable or probable cause, but it is within their jurisdiction, there is justification for their action. What I'm saying is, in terms of 5.1 of the original act, the ordinary man has the right to take action.
Yeah.
But you are now imposing on him a level where he has to prove malice or probable and reasonable cause, which I'm saying you are really putting him out of the picture. And I'm saying that is objectionable.
Well, what we're doing, Madam Chair, is we're not putting him out, the litigant. We're really bringing him to a standard that is perhaps just a little bit less than the judiciary itself in the superior courts, High Court and the Court of Appeal. So what we're really doing, because Senator Ramdeen observed deficiencies in his contribution, what we're really doing is harmonizing this approach a little bit closer to what prevails in the High Court and in the Court of Appeal. So we very much want to do it that way. What we need to do, as Senators Vera and Ramdeen have noted, is we perhaps need to go even further to treat with the whole of picture perspective, which is what we want to do by way of our statements that we're going to deal with that in the other courts of superior record.
Senator Ramdeen?
consider changing the "and" to "or." in the second to last, I think is in the second to last line.
You mean to link subclause 1 and 2?
To disjunct the probable cause, the reasonable and probable cause from the malice. And I'll tell you why. As it presently stands, right, you virtually have to prove that a magistrate was, you'd virtually have to satisfy the same conditions that you have to satisfy in a malicious prosecution against a magistrate if it is conjunctive, meaning that the person has acted maliciously and without reasonable and probable cause. Now, if a magistrate, if your policy is to not go all the way, and therefore you are still leaving the door ajar in relation to somebody who does something outrageous, meaning you act maliciously out of pure spite, right? If a magistrate does something out of pure spite, Attorney General, there should be no requirement for that person who has been the subject of that action being purely spiteful or in bad faith, let's use those legal terms, to have to go and satisfy an additional requirement of acting without reasonable and probable cause. Because you can have a situation like in the anti-gang. What had happened in the anti-gang matters is that Justice Barrow found that there was reasonable and probable cause, but no malice. There was an absence of reasonable and probable cause, but no malice, and therefore they cut it down in Court of Appeal. So that if you have a situation where a magistrate has acted purely maliciously in bad faith, I see the rationale for allowing someone, if you are going to say we are going to still allow people to go against a magistrate, to say a magistrate who has acted maliciously, why should they have that protection? Just as though a magistrate who has acted without reasonable and probable cause. And it'll be more difficult for somebody who's exercising a judicial function. When a police officer is exercising an executive function in carrying out his duties, it is even more difficult for somebody who's exercising a judicial function to prove lack of reasonable and probable cause, because of 99.9% is that he would be acting with reasonable and probable cause in the execution of his duty. So that I see there is a high degree of merit in disjuncting both of them and still achieving your policy, which is that somebody who acts in this type of manner, right, should not be given the protection that you don't want to give them.
Well, may I? The difficulty with disjuncting is that the higher of the two standards is the malice, the lack of good faith, the bad faith, if I want to use that maliciously. So malice has a fairly high standard attached to it. If we went to or without reasonable or probable cause, we're really diluting that position.
But let me just comment on this as you say that, not to have an argument, just to say that the law as it presently stands recognizes that an absence of reasonable and probable cause may be a basis upon which you can imply malice.
Yes, but the point is that it may be, and there are cases that go in all sorts of directions with respect to reasonable and probable cause. If the recommendation was, but my own view of this is that without reasonable and probable cause is the first step, and then the malice is the second, because it's easier to climb the step of reasonable and probable cause. If the submission was that you remove and without reasonable and probable cause, well then you're still left with the malice. But I would think it dangerous to have reasonable and probable cause on that lower footing than the malice, because then we're back to Templeman's position about the hand and Diplock's position about the hand shaking, whilst you're looking over your shoulder in terms of your within and without jurisdiction sort of approach, because the reasonable and probable cause also attracts to jurisdiction issues itself, even though we've exculpated them in the clause before. So I was happy with the qualification being associative, malice, and reasonable and probable cause, because it fine-tunes the argument there. So I didn't see that the reasonable or probable cause was anything other than a lesser standard of malice, but I would think it dangerous if we use the disjunctive or as opposed to and.
All right.
Senator Choate.
Thank you. Madam Chairman, Honorable Attorney General, I just have a query. Action and cause are already defined in the Supreme Court of Judicature Act in a particular way. We are now using a different definition for action. Should we try in some way to harmonize the reading of the two pieces of legislation?
The reason why we stuck, so it's a good invitation. The reason why we stuck with action was because of the wording in subclause 2, which we maintained, which kept it within the realm of action. So because we're not repealing and replacing the law yet, in an omnibus sort of way, we tried to keep with the architecture and the wording of the law as it was passed then. So we were slaved, if I could use that expression, to subclause 2, which is used throughout the legislation.
Thank you.
Senator Vera?
Thank you. My concern, I tend to agree with Senator Ramdeen on using or instead of and. What we have at present is that a person who's injured by an act done can bring an action without having to allege that the act was done maliciously and without any reasonable and probable cause. But now we're reversing it. You're saying, look, you have an indemnity, save that I can show that you did something, that you had a particular state of mind. And I think that's where we're going now. And so saying that the only way you can maintain your action now, and we're bringing a serious thing, you have to go both with maliciously and without reasonable and probable cause. I tend to think you may want to say it was done maliciously, dishonestly, or without reasonable and probable cause. At least that way there's a little more flexibility and give without such a high threshold being put.
So we kept to the high threshold of malice because all the dicta for 1907 come forward, including our own Court of Appeal, have held on to the issue of malice, largely because of the treatment with which superior courts are managed. So it really is when you get to a judge being malicious that you have in the High Court and in the Court of Appeal that you have a similar form of remedy, albeit at the common law. The reasonable or probable cause is to literally throw the baby out with the bathwater, if we use the disjunctive, because anybody could raise that argument at any point in time. As anybody in the criminal law, far be it for me to say that because I'm not a practitioner in that realm, would be able to testify. So I'd be very uncomfortable from a pure policy point of view in using the disjunctive.
Reasonable and probable cause is a very vague and an easy bar to cross. What about maliciously, dishonestly, or without lawful justification?
Again, in doing the research on the Income Tax Act, actually, I came across all those standards in detail. I went for reasonable grounds, mere submission, arguable case, dishonest, and in doing the research for that particular law, in seeing what the threshold ought to look like, it was a landmine it was acres of landmines at play because they are so widely different from each other in certain circumstances. What we felt comfortable with at this stage was sticking with what the dicta of our Court of Appeal, the Privy Council, the House of Lords, the Supreme Court of Jamaica, all had to say, which was go for malicious. It's not too far off of Section 44D of the Central Bank Act, which is bad faith, because bad faith is as high a standard as maliciousness is. But respectfully, we're still at the stage of passing through. There must be a harmonization of standards for all courts of superior record, as one could properly argue the magistracy is. One might even argue that, say, for the tenure, that the magistracy really ought to be in the Constitution, because the whole security of tenure argument is at sea from a whole of government perspective, whole of constitution perspective. I can, and I'm saying this now as an individual, I can see no reason why a magistrate ought not to have that form of protection, which we've effectively given via the JLSC incorporation in implied and in express terms, depending upon which statute you look at. So this really does involve a little bit more weight, because if we take the industrial court, we have 2 JLSC appointments. We take the land tribunal, we take the property tax tribunal, the adjudication tribunals, we take the equal opportunities. Environmental Commission. We have now so much traversed the boundaries of what was a court in 1917 versus what was an out court or inferior court in another point. At the time to at least give that protection is now security of tenure, service commission backing, as well as the prerequisites for immunity. So I'm respectfully asking that we leave it the way it is, specifically because maliciously is followed by the words "and without reasonable and probable cause." And without reasonable and probable cause is a low standard. You'd have to traverse that anyway to get to malice, because malice can be inferred from the very things that Senator Ramdeen referred us to, and this is the stepping stone to get there.
So, Honourable Senators, Senator Mark, I think that we have had ample discussion on this clause. So I will now ask, the question is that clause 4 now stand part of the bill. Those in favour say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 4 now stands part of the bill.
New clause 4.
The question is that new clause 4 be read a second time. Those in favour say aye. Aye. Those against say no. No. All right. All right. Senator Mark, are shall we be proceeding with new clause 4? Do you want to proceed with it?
Of course, ma'am.
All right. So I will, honored senators, the question is that new clause 4 be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 4 will now be read a second time. Senator Mark?
New clause 4.
Yeah, Madam Chair, again, we have argued on this side that the issue is not the provision in the Act per se and the judgment coming out from the courts, but more in the context of the consequences of the provision, which is seeking to exonerate or protect the magistrate from personal liability. And the amendment that we have put forward is to ensure that the magistrate is protected like a judge, and in those circumstances, let all costs or damages be a direct charge on the consolidated fund. And we believe that would go a long way in bringing about genuine immunity for the magistrates.
Attorney General.
I thank Senator Mark for this recommendation. It's laudable and it's noble. The difficulty that I have with it at present is that it would cross into a realm of inequality, because I don't have an indemnity. This is effectively an indemnity clause. It's saying, look, you'll pick up the bill, taxpayers will pick up the bill. It's a charge on the consolidated fund, like judicial pensions, like judicial salaries, etc. But the judges don't have an equivalent clause. The industrial court doesn't have it. And specifically, the State Liability and Proceedings Act, Section 2.2, excludes judges, magistrates, and other judicial officers. So for me to pluck out of the judicial and of the State Liability and Proceedings Act, Section 2.2 exculpation for Section 4, I find myself treating people potentially in similar circumstances dissimilarly, which is an intrusion into our constitutional rights. Secondly, I run into an implied repeal argument. Thirdly, I run into the fact that we haven't yet factored the effect on the whole of immunity conversation that we need to have. The other thing that troubles me is that magistrates have a different level of qualification to become magistrates. So under the Summary Courts Act, when we introduce magistrates as creatures of statute in sections 3, 3A, 3B, 3C, if I remember the numbering correct. 3 and 3A, and there's a 3C2 which says immunity. I can't remember. I don't have it with me just in front of me, but thank you, Senator Hussain. Here we go. So if we look to that particular act, it's 3A, and there's a 3B. So 3A, no person shall be appointed as a magistrate, must be admitted to Trinidad and Tobago, practice for a period not less than 5 years. When I go to judges, I have a slightly different standard. If I go to the industrial court, I have a different standard. And even though the JLSC does the recommendations, and they do it so on contract, which is 3B, my problem with introducing the indemnity provision that the new clause 4 suggests is that we don't yet have an opportunity to do the consultation with the other stakeholders that really ought to be caught in this basket. So I think it's a noble suggestion. I think it really ought to be something that is applied across the board. But then again, one has to balance the question, is there a mischief to be had in just saying, go ahead and do whatever you do because I'll pick up your tab? Because the complete indemnification and exculpation of even a judicial officer is to allow them to do anything they want regardless, because the taxpayers pick up the burden. Right now, there is in the Balancing Act the need for some sort of sword if you've acted maliciously, without good faith, bad faith, whatever you want to call it. So one could argue on the other side of the coin in legislation and being judicious in the approach that perhaps you really ought to have a circumstance where civil liability does attract in some form or fashion. So I respectfully recommend that we don't proceed with the new clause 4A because A, we're not complete with the discussions, and B, because the Balancing Act of complete exculpation and indemnification could be potentially dangerous.
Senator Ramdeen.
Thank you, Madam Chair. Madam Chair, I don't want to be said to be sitting here and not putting forward what I think is a proper position, which is that courts of superior record, which is the commissions that the Attorney General speaks about, the Industrial Court, the Integrity Commission, the Equal Opportunities Commission, because they are courts of superior record, that is the reason why they can't be sued. The State Liability and Proceedings Act, the definition of judicial officers not being present as a servant or agent of the state, is only limited to proceedings for contract and tort, which is the old what we considered 1947 Crown Proceedings Act. So that is not a good reason for this to saying that there is a difference in treatment, because all superior courts of record cannot be, any court of superior record cannot be sued in judicial review proceedings for the simple reason that the characteristics of that tribunal are such that it is a superior court of record. It has inherent jurisdiction. It has the power to hold people for contempt. And therefore, that is why, if we are saying that we want to give magistrates the same protection that they are afforded as judges of the High Court or members of the upper judiciary, the fact that there is a difference in qualification just simply limits the jurisdiction that is exercised by the judicial officers. And therefore, respectfully, there is no issue of discrimination arising and different treatment, because the different treatment doesn't trigger the discrimination clause in the Constitution. It is whether the different treatment can be justified, having regard to the circumstances of each person that is subject to the treatment. And therefore, in those circumstances, I think that there is still a strong case for advancing the amendment as put by Senator Mark.
Sure, Madam Chair. It's precisely the tortious point that I was on, because it certainly is something, I mean, Senator Ramdeen's reflections may or may not be true. The truth is that I can't decide that here right now in the vacuum that I'm in, but I'm on the point of tort in particular because the State Liability and Proceedings Act provides the explicit opening for the realm of tort. And that's what we're talking about. So when we look to the Bermuda law, we're talking about civil tortious liability. And we preserve the fact that magistrates who act in criminal purpose can, in fact, be brought to bear, so too judges, so too others. But the point is that, again, in summary, the fulminations are not complete in the whole of structured position. I can't say now, from this position today that I accept or reject wholeheartedly Senator Ramdeen's submissions. Perhaps he's right. I just have not been able to do the deviled work, the material of digging behind the hard law to come up with that. And very importantly, we're talking about the tort and the exculpation of, well, the exception for application of the State Liability and Proceedings Act within the meaning of sections 2 and 4.
So, honorable senators, the question is that new clause 4 be added to the bill. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. So new clause 4 is not part of the bill. Honorable senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Attorney General.
Yes, please. Sorry, Madam Chair, I was distracted by the leader of the bench. Perhaps it's because I'm sitting in his seat temporarily. Madam President, I wish to report that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honorable senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it.
Mr. Khan? Yes. Mrs. Gopi Schoon?
Yes.
Mrs. Batiste Primus?
Yes.
Mr. Rambharat?
Yes.
Mr. Sinanan?
Yes.
Mr. Moses? Yes. Mr. Hussein?
Yes.
Ms. West?
Yes.
Mr. Lehont?
Yes.
Dr. Henry?
Yes.
Mr. Singh?
Yes.
Mr. Cummings?
Yes.
Mr. De Freitas?
Yes.
Mr. Dookie?
Yes.
Mr. Simonet?
Yes.
Mr. Mark?
Abstain.
Ms.
Abstain.
Thank you. Ms. Haynes?
Abstain.
Ms. Amin?
I abstain.
Mr. Hussein?
Abstain.
Mr. Obika?
Abstain.
Mr. Ramdeen?
Abstain.
Mr. Richards?
Yes.
Ms. Chot SC?
Yes.
Mr. Vera?
Yes.
Dr. Dial Singh?
Yes.
Ms. Dionarang?
Yes.
Ms. Seepersad?
Yes.
Mr. Timol?
Yes.
Mrs. Thompson-Ahye?
Yes.
Dr. Dylan Remy?
Yes.
In the explanatory note does not form part of the bill, but there is an interloper there that should be put out.
Senator,
Close.
Senator Thompson-Ahye, I think we are past that now because we are now having accepted the report. We are actually going through the procedural motions, okay? The Attorney General, though, will take note of your comment. Yes. Honorable Senators, the result of the division is as follows. 24 members voted for and 6 members abstained. No one voted against. Yeah. Attorney General.
Thank you, Madam Chair. Madam President. Madam President, I beg to move that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be forthwith read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be now read a third time and passed. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I beg to move that the Senate do now adjourn to Tuesday, the 18th of December, 2018, at 10:30 a.m. in the morning. On that day, we will be debating the finance bill. Tuesday, 18 December, the finance bill, which should be debated in the House tomorrow. I just want to put members on notice that very likely we'll be also meeting on Wednesday, the 19th, which will be the last session for the year. We will be doing a miscellaneous provision bill that is related to the income tax amendment bill and FATF. Wednesday, very likely 1:30.
Honourable Senators, we will deal with that as we okay?
But
yes.
Just giving you a head.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised. Senator Obika.
Thank you very much, Madam President. I rise at this opportune time to highlight the need for the government to effect improvements in the PTSC operations and service in southwest Trinidad. Now, Madam President, before today's Parliament sitting began, I solicited the views of persons from Point Fortin, La Brea, and Cedros regarding the quality of service that they have achieved. And I wish to state on the record, the first person, Point Sando, not so reliable. The second responder, poor service. Service in Granville was stopped. Granville to Port of Spain, stopped. Sando service to Caracas runs on weekends, but not reliable. The third responder, buses from Point Fortin to Port of Spain along the Southern Main Road, the buses regularly shut down. Oftentimes, only one bus works. This information, however, is only conveyed to travelers just at the time when the bus won't come after waiting for several hours. That responder proposed a solution that a bus probably should be held in reserve. You know, one would have expected that would be the normal order of business. And the person also said, to make matters worse, the road from San Fernando to Point Fortin has not been paved since this government has gotten into office. And I'm hearing members from the government side saying that are going back, dealing with what they believe is not the motion before them. But I want to remind them what the motion is. The need for the government to effect improvements in the PTSC operations and service in the southwest peninsula of Trinidad. Now, if the complaint is that the bus always breaks down, clearly, if the bus traverses a roadway, and if the roadway is impassable, that probably would be one of the main reasons why the buses are breaking down.
You had to get them the minister number.
So, and the sad part about it, Madam President, is that the line minister may wish to be seen as a troubleshooter. But in the case of PTSC, all the interventions since this government has come into office has amounted to, all the interventions have amounted to simply trouble. No troubleshooting. Just as the case with the collapsed sea bridge, they have collapsed transportation in the southwest peninsula of Trinidad and Tobago. Now, so that's one. So in terms of benevolence, because of course the government came on a platform of we love you, so we'll care for you.
Let's do it together.
Clearly, they were not considering the persons in the southwest peninsula of Trinidad and Tobago. The second point is competence. But if you can't even provide the buses to ply the routes, then clearly you have to ask the hard question. Is this government is this minister competent in utilizing the resources at his disposal? Now, of course, the Honorable Minister may complain that there was a precursor to him, but there's a reason why the Prime Minister was removed. It's because of incompetence, Madam President. So you can't say that after one incompetent minister, another one comes and the same thing. It can't be the road march that incompetence in their fourth year of office is the order of the day. And the last part that you use to judge someone, if they are not benevolent, so they don't take care of you, they are incompetent. The last thing you would at least hope for is some level of dominance. But, Madam President, in terms of the management of the transportation and of PTSC, weakness is really what you see. Now, the PTSC came before Parliament. I would have you know that in the second session of Parliament, they came before Parliament, and in the executive summary of the JSC, there were some issues that were raised. You know, Madam President, one of the main issues was that the PTSC's performance was not being monitored nor evaluated by the ministry. That the number of passengers transported was continuously falling. And the bus fleet is succumbing to many maintenance challenges. Now, if you have raised the price of super, diesel, and premium since you have come into office, you're in your fourth year, one would expect that the public would have gotten some level of reprieve by an efficient transportation network. So that, okay, if they can't now afford and they're suffering massive layoffs, so they can't even afford to utilize their personal vehicles, at least one would expect that the Public Transport Service Corporation would have been equipped with the proper buses, would have been staffed with sufficient drivers, and would have been given the tools to ensure that the people of the Southwest Peninsula get value for money. However, Madam President, I wish to remind the Honourable Minister of Works and Transport that one of the main recommendations from this JSC was that PTSC must develop and set out to implement a clear strategy for increasing ridership. But as I began my contribution today, I reminded the minister that the public is not seeing any improvement, and he needs to work on those three things we pointed out. You need to take care of the persons, be more benevolent, be more kind, take care of the people, be competent, and if you can't do so, step aside, because we are ready to take care of the people of Southwest and the whole of Trinidad and Tobago when we return to office. I thank you very much.
Minister of Works and Transport.
You finish already? Oh my God. Thank you, Madam President. Madam President, let me thank the Honorable Senator for bringing such a motion, because I am really happy that the Senator would have bring this motion, because I think the motion is very important. It's public transportation, and it's important to take the debate at a much higher level than he had it at. And I can actually give the population that assurance. Madam President, based on the motion before us today, which seeks to establish the need of the government to effect immediate improvement to the PTSC operations and serve the Southwest Trinidad, I take the opportunity to show this Honorable Senate and to ensure the population that there is a strategic plan for public bus transportation service as raised in this matter. Madam President, I too agree that efficient public transportation service is one of the main answers to our traffic problems in Trinidad and Tobago. And Madam President, the Ministry of Works and Transport, in collaboration with the board and management of the Public Transportation Service Corporation, will continue to focus their resources to deliver and improve public bus transport service to the national commuters who depend on the bus service as their primary mode of transport. Madam President, in order to improve the PTSC operations and services, the process of business transformation commenced at the corporation. After thorough review sessions with the board and the management team, the corporation delivered a strategic plan for the period 2018 to 2021. During this review exercise, strategic goals and objectives were established. Business processes were examined and re-engineered, all with the view to alleviate deficiencies and strengthening the corporation core service delivery mechanisms. The strategic plan is intended to serve as a roadmap to guide the successful modernization of the corporation operations to improve the quality and reliability of service delivery to the population. The plan highlights the following strategic goals for the stated period: operational efficiencies, employee satisfaction and engagement, customer service and satisfactory improvement, operational transformation, revenue growth, and diversification. Establishment of a monitoring and evaluation framework, environmentally friendly PTSC. The corporation also developed PTSC Development Plan 2017-2022 with the intention to improve the quality of service provided to commuters. The corporation planned to achieve its new vision for its operation by placing emphasis on the following: upgrading and modernizing the corporation's infrastructure, modernizing of the corporation operations, improving revenue flow, and reducing the dependency on government subsidies. The corporation strives in its decisions to be in line with the Team 3 of the Vision 2030 National Development Strategy 2016-2030, which as follows: improving productivity through quality infrastructure and transportation, improve access to public transportation service, enhance the efficiencies and effectiveness of the national transportation system. Some of the strategic initiative outlined in Team 3 of the Vision 2030 as follows: the corporation is acquiring 300 new buses to its fleet, increased bus stop signs along the north-south corridor, priority bus routes and other routes, development of a new productive service through its east-west corridor pilot project, the mall shuttle service, construction of a first line and repair facility in PTSC Arima Depot, development of a passenger facility in Rio Claro, relocation of the San Fernando garage, and the installation and commissioning of standby generators at all areas. The corporation has embrace the use of information technology with the implementation of a fleet management system, the installation of surveillance cameras at all locations, and a biometric team for attendance system. Madam President, the motion speaks about the Southwest Peninsula, and I can give you the assurance that in 2017-2018, the facilities at Point 14 have been upgraded. However, there is a challenge with the fleet of buses. Most of the buses in the PTSC fleet is over 10 years old. The industry standard should be about 7. And this is why the government took a decision to buy 300 new buses. And when these 300 new buses come on stream, it will not be the same old. It will be coming in 2019. And this decision of 300 new buses, Madam President.
Minister, please. Members, please. I think you, Minister, continue.
Madam President, when these 300 new buses come, it just will not be going into the system just like that, because we have had experiences in the past. We buy new buses, and they don't last too long before we see them on the side of the road crashed or not being properly maintained. This government, unlike previous government, went with a government-to-government agreement. That's right. What that means, there'll be no middlemen. In other words, no contract to be awarded. You wanted to find out how much Devon bought? This government is buying 300 buses with a direct arrangement, a government-to-government arrangement, where it will be in the contract that no commission is to be paid to anybody, locally or internationally. the company that we are buying these buses from will have to put a proposal for proper maintenance, proper training, and will also assist us in a modern public transportation system, meaning we will be using technology to monitor the buses. The commuters can use their phone or any form of device that has internet connection. You can track the buses wherever they are. You can track how late the buses. You will get on an app the time the buses will be there, and if they're not on time, give you an average of time that will be there. What we are hoping for, Madam President, with what we put in place is to have a modern public transportation system. Not only for the Southwest Peninsula, but for the entire country. And I give you the assurance, Madam President, that the country can look forward to a much more modern and organized public transportation in the near future under this government. I thank you.
Leader of Government Business. Leader of Government Business.
Yeah, it's a good procedure motion. Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand.
Honourable Senators, the question is that this Senate continue to sit until the completion of the business at hand. Those in favour say aye. Aye. Those against say no. The Senate will continue to sit until the completion of the business at hand. Senator Mark.
Thank you very much, Madam President. Sorry about that interruption just now, dear ma'am. Madam President, since the arrival on the compound of Trinidad and Tobago by the PNM on September the 7th, 2015.
They arrived in 1956.
Madam President, the people of Trinidad and Tobago, particularly the working people, have continued to reel under the hammer blows of one of the most incompetent, oppressive, evil government that this country has ever witnessed and experienced.
Senator Mark, this is your motion, and I normally allow senators some leeway in presenting the motion. But please, could you dial back a little bit on the rhetoric, okay?
Well, this is not rhetoric, this is a fact. Sorry, ma'am.
All right.
Sorry, ma'am. Yeah, Madam President, over the last 3 years, this government has inflicted unprecedented, brutal, and harsh conditions on the working people, manifested in rising prices, deteriorating working and living conditions, unprecedented increases in the cost of living, exponential growth in crime and criminality, the imposition of an oppressive and repressive property tax regime, and, Madam President, the worsening distribution of income and wealth between the haves and the have-nots in our country. Madam President, this country has experienced what can only be described as joblessness over the last 3.5 years, where workers' purchasing power has declined along with a sustained assault on their wages and salary packages, Madam President. Madam President, would you believe that over the last 36 months, we have had thousands, in fact, we have estimated close to 50,000 workers who have placed and who have been dumped on the unemployment garbage heap by this government led by the Prime Minister. Madam President, underemployment has worsened under this regime, and they speak about labor reform, but it continues to elude this intellectually bankrupt Rowley administration. Madam President, would you believe that they made promises to the working class, the trade union movement, that they will introduce and bring about reforms to the labor regime in the context of Retrenchment and Severance Benefits Act. They would revise and they would repeal. They would establish a severance benefit fund, Madam President. Madam President, these things have never appeared on the horizon. And I give you the undertaking tonight, this evening, they will never arrive on the political horizon. Madam President, you know what has arrived? Massive retrenchment. Over 10,000 workers gone at Petrotrin. That is what has arrived, Madam President.
Senator Mark.
Sorry, Madam.
Please, there is absolutely no need to be shouting, okay?
I'm trying to breathe, sir, ma'am. We're not breathing. Allow me. But understand, Madam President, in terms of retrenchment, right, Madam President, over 10,000 workers gone at Petrotrin. Madam President, they want to bring something called the TTRA. In that regard, 2,000 and more will be going. WASA, the Minister of Public Utilities, has indicated that it is overstaffed by over 2,000 workers. We anticipate trouble at WASA. We anticipate more trouble for workers at TNTech. Madam President, already TSTT has retrenched over 500 and 300 more workers are to go. So, Madam President, what the government has been doing over the last few years in office is making life more difficult and challenging for the working class of our country. They have betrayed, Madam President, all the promises that they have made to the working class. They have undermined collective bargaining in the country. They have sought to decertify trade unions in this country, Madam President. So this government, Madam President, has offered no real hope for this nation. Madam President, would you believe that we have been told by the government that they will introduce, Madam President, comprehensive reform to the Industrial Relations Act. Madam President, the government is on its way out. As you know, this government is on its way out, Madam President. And it's only a few more months again before we sung the funeral drums. Madam President, the government promised workers a new Industrial Relations Act. Madam President, no Industrial Relations Act. They promised the workers of our country a Retrenchment and Severance Benefits Act, a revised one. None has appeared on the horizon. Madam President, they promised the workers a modernized and reformed new Occupational Safety and Health Act. It has not arrived. What about sexual harassment legislation, Madam President? Workmen's compensation, they promised the working class. That has not materialized. Madam President, they promised also a basic conditions of work legislation. That too is yet to arrive, Madam President. Instead, Madam President, what we have witnessed over the last 38 to 40 months is union busting at its best. Madam President, nobody ever could have contemplated that the Dr. Rowley, the Honorable Prime Minister-led government would have been so vicious against the organized trade union movement. When you take into account that they signed a memorandum of understanding with the trade union movement before they took office in 2015, Madam President, and today, one of the leading lights that were at their side, Madam President, the Oil Fields Workers Trade Union, Madam President, is now fighting for its very survival in South Trinidad and in the oil industry today. So what the government has done, Madam President, they have almost decertified the trade union movement, that is the OWTO, from Petrotrin. So the union movement has disappeared literally at Petrotrin. And I want the government to indicate tonight, when they rise to speak, whether the OWTU will continue to represent workers at Heritage, at Paria, at Garakara, and at the Petroleum Holdings Company in Trinidad and Tobago. Tell us, Madam President, if they are really serious about successorship and continued union representation. So, Madam President, what is going on in Trinidad and Tobago is that we have a government that is anti-worker, anti-trade union, anti-people. And I give you an undertaking this evening that the working class and the ordinary people are only waiting for the election bell to be rung in this country to send the PNM packing, Madam President, once and for all. I thank you, Madam President.
Minister of Labour and Small Enterprise Development.
Madam President, I rise to address the motion filed by Senator Wade Mark through your good self, which reads, the failure of the government to actively pursue reform of the labor laws of Trinidad and Tobago. And I want to thank Senator Mark for moving this motion because it affords me the opportunity to report to this nation, not only to this House, but to this nation, what we at the Ministry of Labor, we have been engaged in. Madam President, the government, and by extension, the Ministry of Labor and Small Enterprise Development, appreciates that in some instances, the existing legislation could be considered archaic and possibly irrelevant to the current socioeconomic realities and the way that work is done generally. The government of Trinidad and Tobago, through the Ministry of Labor and Small Enterprise Development, has concretely and consistently demonstrated its commitment to the reform of labor laws of Trinidad and Tobago early into our term. The government has pursued labor reform legislation, Madam President, and to my good friend, Senator Wade Mark, in keeping with several key aspects of the national policy framework, the realization of which, with respect to labor, is inextricably linked to the success of our labor legislative reform project and will result in labor issues and labor legislation emerging as a positive force in the economic development of Trinidad and Tobago. Madam President, in fact, the very first labor legislation reform consultation took place in respect of the Industrial Relations Act, Chapter 8801, on February 22nd and 23rd, 2016 in Trinidad, and on the 8th of April 2016 in Tobago, whereby the ministry conducted a national tripartite stakeholder consultation on the Industrial Relations Act over the course of 3 days. As a matter of fact, Madam President, just today, the National Tripartite Advisory Council held its meeting where we concluded consultation with NTAC on the Retrenchment and Severance Benefit Act, and the comments of the council will go back to Cabinet week after next.
Good work.
Madam President, thereafter the Ministry of Labor and Small Enterprise Development has sustained its commitment to engage in tripartite stakeholder consultation. And I want to record the following. From 2016 to date, stakeholder consultations were conducted as part of our labor legislative reform project in respect of the following pieces of legislation. The Cooperative Societies Act, we had one in Trinidad, one in Tobago. The Retrenchment and Severance Benefits Act, one in Trinidad, one in Tobago. The Basic Terms and Conditions of Employment Code, one in Trinidad. Occupational Safety and Health Act, one in Trinidad, one in Tobago. The Workmen's Compensation Act. Every one of these consultations, we held a similar one in Tobago. The Cipriani College of Labor and Cooperative Studies Act. The Friendly Societies Act. Private security legislation. The draft National Workplace Policy on Sexual Harassment in Trinidad, in Tobago. The Trade Union Act and the Employment Standards Code, one in Trinidad, one in Tobago. As a consequence, Madam President, of all these consultations, Senator Wade Mark, unprecedented. Your former administration never held so many consultations, not one amendment. They attempted to have an amendment. Madam President, I demand that when I speak, the opposition listen. I sit here and I say nothing when they're speaking. I request your protection, Madam President.
Honourable Senators, please, the standing order requires everyone to be silent while someone is making a contribution. Continue, Minister.
Thank you very much, Madam President. Madam President, arising out of the unprecedented number of consultations held, I did not do it, Madam President. I have an excellent team of public officers working with me. They work beyond what is necessary, and I'm very proud to lead that team, Madam President. Arising out of these consultations, several draft policy papers have been prepared, including a draft policy paper for the amendment of the Cooperative Societies Act, a draft policy paper for the amendment of the Retrenchment and Severance Benefit Act, submitted to Cabinet, I said a short while, sent to NTAC, and NTAC has now completed its consideration of that draft policy, and it goes back to Cabinet. A draft policy paper for the amendment of the IRA. Today, NTAC took a decision that we will meet on the 22nd of January and devote our time to the amendment to the Industrial Relations Act. A draft policy paper for the amendment of the Cipriani College of Labor and Cooperative Studies Act. That went to Cabinet and it is engaging Cabinet's attention. A draft policy paper for the amendment of the Friendly Societies Act. A draft policy position paper for the Employment Standards Bill. A draft policy paper for the National Workplace Policy on Sexual Harassment. And I dare say, right now, as I speak, there is a draft Cabinet note forwarding this draft National Workplace Sexual Harassment Policy for the consideration of Cabinet.
That's right.
And also, Madam President, a draft policy paper for the amendment of the Occupational Safety and Health Act. Madam President,
Unprecedented.
us at the Ministry of Labor, we do not go on the rooftop and shout about what we are doing. We have been working quietly but diligently and in a sustained way to ensure, Senator Wade Mark, labor legislation. I was the chief architect of that memorandum of understanding between the Joint Trade Union Movement and the People's National Movement. Not everything we do in life, not everything happen in life, Senator Wade Mark, we are comfortable with. But such are the vicissitudes of life. Madam President, the Ministry of Labor and Small Enterprise Development team has been working diligently and consistently on the reform labor legislation. Since 2015, such a high level of performance in this ministry is simply unprecedented, and we will continue to be focused and we will get the job done. I thank you, Madam President.
Honourable Senators, Honourable Senators, the question is that this Senate do now adjourn to Tuesday, the 18th of December, 2018 at 10:30 a.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to Tuesday, the 18th of December, 2018 at 10:30 a.m.